From what? From. Okay. Yeah, so look at it and then read what is stated over there. The command at the tail end of the rates. Now, I've shared some real life rate samples with you too, isn't it? Then it's, yeah, so just read what is there. Use this. You know, my friend is struggling hard to get back previous favor.
Also, the streets were hereby commanded.
That's really good. For from the days of issue, unless it is renewed within 6 calendar months from the date of that renewal. The defendants may appear to by filing a notice of appearance, either personal or by a lawyer for filing at the registry of the court of issue of the rating acts.
No, please. I think, excuse me, give me that. I think you are misleading us. Seriously annotated. Okay. So read the correct one for us.
And also the issue and that in the form of a soul book, definitely in your assent.
Good. So we are discussing judgment in default appearance, and we've made the point that if you take the rate of sermons on the face of it towards the bottom, there is a warning or command that if you default, if you fail to enter appearance, judgment will be entered what? Against you. So let's keep that in mind. And from what you read in the law, Order 10, Rule 1 and 2, we get to know that we have two types of judgment in default of what? Appearance. So we have a final judgment and then interlocutory judgment. As whether the judgment in default of appearance you obtain is a final one or interlocutory, it depends upon the nature of the claim. And when we say the nature of the claim, we are talking about the relief or the remedy, which was endorsed on the rate of what? Summons. That is the nature of claim we are talking about. So therefore, if it is final, of course, it also has consequences for appeal. Because if you are appealing a final judgment, what is the time period under the law? You have 3 months in the first instance, isn't it? And then you can go for extension for another 3 months. And then after 6 months, you have exhausted the rights. Good. Now, apart from that, if it's an interlocutory judgment or interlocutory order or ruling, you want to do what we call interlocutory appeal. From the date of the decision or the order you are aggrieved by, for which you want to appeal, what is the time period within which you are supposed to appeal? Yes.
21 days.
21 days. Some of you are lawyers already. Good. 21 days. Yeah, so the decision will also determine the timelines for appeal, as the case may be. Because it's a final judgment and you have to appeal 3 months, 3 months, 6 months. If it's interlocutory, you have 21 days. But interestingly, 21 days, after expiry of it, you cannot go for sanction. Some lawyers make that mistake. And when they have exhausted the 21 days, they think that just as in a final judgment, if you run out of the 3 months, the rules allow you to go for sanction so long as another 3 months have not elapsed. They think the same logic applies for interlocutory appeal. It doesn't work that way. And we'll be told later on that appeal is a creature of statute. One of the areas of the law which is very strict is when it comes to appellate litigation and appellate jurisdiction. The reason being that you are trying to have a second bite at the cherry. And for that matter, you are restricted. So everything is rigidly prescribed. But later on, when we are dealing with appeal, before we say more things about this. So what is a liquidated claim, which entitles you to a final judgment? When we say a liquidated claim, what is it? Yes. A sum certain. Good. So can you break it down further for you? Are correct. Can you break it down? A sum certain. What is the name again? Madeline. What the demand is. Okay. So a claim where you know the exact amount, or the amount is capable of being what? Ascertained, as it were. But when it comes to liquidated claim, and for that matter, liquidated final judgment, the court cannot give more than what was endorsed. And Justice Anine Boasi then was in the Asamoah against Mafu, 2010 SCGL will remind us that when it comes to judgment in default of appearance, the judgment entered must be for the actual amount claimed. The actual amount claimed, and there's no discretion in the matter. And he cited the case of Bonsu against Doe. Bonsu against Doe, 8684 JLR 778, where the court speaking made the point that, quote, the legal position is that a judge may set aside a judgment entered in default either of appearance to the writ or delivery of pleading of appearance when the judgment was entered for a greater amount than was due, or where there had been a breach of good faith. The judgment will be set aside as debito justitia, quite apart from any consideration whether there was a good defense on the merit. Then he cited the Hospice Laws of England. And so he will just make the point that when it comes to judgment in default of appearance, particularly in talking about liquidated demand, talking about final judgment for liquidated claim, it must be exactly what was endorsed. And you cannot give more than that. So that is important. Now, when it comes to summary judgment, we'll talk about the 14 later on, where there is no, for judgment in default of appearance, at that stage, you're not supposed to prove anything. Because the other person, the only basis entitling you to it is that the other person has defaulted, isn't it? And you said that you are sued for recovery of 10,000 Ghana cedis, being the price of goods supplied. The person has not entered appearance. So at that stage, the law, you are not required to really prove anything. But if, for example, it had been recovery of the value of 100 bottles of whatever item supplied. Now here, you have not told us the exact price, but giving us an idea of how to maybe compute it, isn't it? But an issue may arise as to whether that will entitle you to final judgment. No, you may get what we call interlocutory judgment, but that will be unliquidated claim. And you need to go and do assessment of what? Damages. You bring evidence for us to ascertain. The boxes are talking about how much was won. Then when we know that, the court will be able to compute and say that, okay, if you are saying that the value of the 100 boxes, then this is how much it is. But it's different. If you had, for example, stated that 10,000 Ghana cedis being the value of goods supplied. So in that case, if there's a default of appearance, we know the exact amount you're looking for. Then the court can give you judgment for that. We'll talk about summary judgment later on, and order 14. That one is similar, but not exactly. Because summary judgment, all that you are saying is that for the claim that you have made, it's indefensible. There's no way the defendant can do what? Can defend it. And you have enough proof at that stage to let the court be convinced that the amount or whatever you're looking for, you're entitled to it. And the court does not need to conduct a trial to prove that, for which reason the process should be abbreviated or shortened. And that's why we say summary, instead of having elaborate trial to establish that. We'll come and talk about that pretty soon. So I think what we should keep in mind now is that liquidated claim is where the sum is certain, or the amount of claim is fixed, is determined, as it were. And the court cannot give judgment more than what? More than that, as it were. We've seen the authorities. Now, unliquidated demand or unliquidated claim is the reverse. So, for unliquidated demand, the amount is not known or is not spelled out, is not indicated or fixed. So we need to go through some processes of proving before the court will be able to know what should be given you by way of judgment. So where there is a default of appearance, you go and get interlocutory judgment. So when we say interlocutory judgment, it means that you need to take another step. You have to go and do what we call assessment of damages. Interlocutory judgment is only say that, yes, the other party has defaulted in actually doing what should be done, entering appearance. So you're entitled to judgment, but we don't know what exactly should be given to you in judgment. So you need to come to the court and let the court be convinced regarding what the judgment should actually be. And that's what we call like the assessment of what? Of damages. So if you look at the practice, what happens is that writ has been issued, they have been served, 8 days, 10 days, or whatever days have elapsed. You have to write a letter to the registrar. To conduct a search. And then when you write a letter to the registrar to conduct a search, we will ask certain questions in the letter that the registrar should cause a search in his records or the registry to find out whether the writ of summons and the statement of claim have been served, whether it has been served on the defendant. If there are more than one defendant, has been served on first defendant. If yes, when? Have been served on second defendant. If yes, when? Have been served on third defendant. If yes, what? When? And then you ask another question. Whether the first defendant has entered appearance. Dash. If yes, when? Whether second defendant has entered what? Appearance. If yes, when? depending upon the number of what? Defendants. But you need to break it down because you must serve each defendant. So you cannot just say that whether the defendants have been served. You need to break it what? Down. And they may not be served at the same time. So maybe one defendant was served last week, and then the judge this week got another defendant to do what? To serve him or her. So in computation of the time, it will be different. Like the time for filing appearance, those who were served earlier will definitely, their time will come earlier than the, so that is how it works. So when you obtain the response or the reply from the registrar, usually they'll do it on the same letter that you sent, then you put their stamp on it. You are learning law and practice, so you have to listen well. And that's what happens on the ground. When you go to the law firm, the lawyers complain that the students, they don't know anything when they come to the chambers because of how the course is taught. This is procedure, it's not theory. So you have to learn both what happens on the ground and as it were. So that right from day one, when you are given work to do, you know what to do, what to do. So when you get the response from the registrar, like as I said, usually the same letter you send is what you put the responses on. Based upon the response, you know whether he has defaulted in entering what? Appearance. Now, not until you have ascertained, you cannot file motion for judgment in default of what? Appearance. You must always conduct the search to ascertain. So let's keep that in mind. And then when you do the motion, will it be motion on notice or motion ex parte? Why motion ex parte? Yes. Yes.
And the respondent didn't, the defendant didn't respond, or he didn't interfere, so there's no need for, because it's been warned in the writ. It's been warned in the writ, so you don't need to give him further.
Right. So the writ itself has told him that if you don't enter appearance, a judgment may be obtained but against you. Good. So you go ex parte. Can you prove that from the rules? From the rules, can you prove it? That application for judgment in default of appearance should be ex parte. Yes. The question is simple. You said motion or application for judgment in default of appearance should not be on notice. It should be what? Ex parte. That's okay. If that is your position, convince me from the law so that I come along with you. So tell me, how do we know? Yes. Yes. Can you use the mic? Can you give the mic to him so that?
Hello.
Yes.
I was saying that by order 19 with the rate. See that the motion is valid and be by in accordance with or everyone considers that it's appropriate to do so. So having a raising commanding somebody to come render appearance and that in default judgment will be made against him and the person defaults in kind is circumstance where the all is that third party motion is
Right. Good. Yes, so you are right. Motion for judgment in default of appearance ordinarily could be ex parte, but I will always recommend that go on notice. The same means which was used to serve the writ, use that same means. You are the plaintiff. Because if you go ex parte, later on the person will come and set it aside. And if you believe in your claim and you want things to be expedited, so when it comes to litigation, it's a strategy. You are the plaintiff. Especially if you are confident in the claim for which you have gone to court, you wouldn't like anything to delay you, isn't it? Now, if you are a defendant and you don't have a good case, that is where you indulge in technicalities and every little procedural advantage, you want to exploit it. But you are the plaintiff. You are very certain that this case, there's no way that will lose. The claim is so solid, the evidence is so solid. So you don't want anything to be delaying you, isn't it? So you go for no judgment default of appearance, yes, ex parte is given to you. Later on, when you go and serve the entry of judgment, assuming is a final judgment, yes, you will come and take the step to have it set aside. If it is a interlocutory judgment, and of course, interlocutory judgment is a requirement that when you are going to do the assessment of damages, you must serve notice of the assessment of damages on him or her. So maybe for interlocutory, for unliquidated claim, interlocutory judgment, you may decide to go ex parte. But then when you are going to do the assessment of damages, that is when a date will be fixed for you to go and enter the witness box and satisfy the court regarding the claim. You have to be on notice with the defendant. So there's nothing wrong to go ex parte. And it's also not wrong to go on what? On notice. And in fact, if you look at Order 19, there's a presumption or there's a default preference that everything should be on what? On notice, isn't it? Is that not the case for Order 19? Yeah, so if you go on notice and it can be served on the other party, you are not wrong. So where it is unliquidated claim, as I said, there are two steps. You first go and get interlocutory judgment, and then you have to come back for assessment of what? Of damages. When we say assessment of damages, it simply means that you come back, enter the box, and prove whatever claim which you made in your rate, which has not been specified. If it's specified, then you get the final judgment because it's a liquidated claim. So do we get a distinction between a claim for unliquidated demand and a claim for liquidated demand? If noted claim for liquidated demand, you get a final judgment. And then claim for unliquidated demand, you get interlocutory judgment. And interlocutory judgment means that you have to go back to court and do assessment of what? Damages. Now let's look at another type of yes. Yes, please.
Is there any particular reason why these would enter the final, no, I mean, until we receive
Judgment.
judgments, and once the final judgment, you have to go back.
Okay, good. It has to do with the nature of the claim. As we gave examples, let's say that in a writ, plaintiff is claiming or seeking recovery of 10,000 cedis, being payment for services rendered or being value of goods delivered. Now we know how much debt you say the defendant is owing you, 10,000. And let's take another scenario. Plaintiff's claim is for recovery of the value of goods carried by plaintiff's truck from Kumasi to Tamale between February and April 2025. So this can be a legitimate endorsement or a claim on the rates. Now you have served the defendant the rates, and in terms of the rules, there's evidence of due service. You have established that it's been served. The rule says that you can get a default judgment. But if you go and take the judgment, how much money are you supposed to actually take from the defendant? We don't know yet, isn't it? But then the first scenario, where you are specified 10,000, we know it. And this second scenario is not just a question of being capable of easier ascertainment. You need some other things. You need to, for example, bring evidence that, yes, there was actual carriage. You bring all those things, and then how much, everything, before the court will be satisfied. And for interlocutory judgment, it is what you'll be able to prove, which will be given the award. So therefore, if you're able to prove just 2,000 Ghana cedis when you enter the box, the court cannot give you more than what? 2,000 cedis. But then if it was like a liquidated claim, and you have specified, you don't need to go to the boss and actually approve anything. Yes.
My question is to the fact that it's not a waste of time. If you just apply for a final judgment for the specific sum, rather than give a description of the debts, and then you subsequently have to.
Okay, good. So that will be done at the time of you preparing the writ, because the nature of the claim is crafted or written when you are making the writ, isn't it? When you are going to get the registrar to issue the writ, you have actually stated your nature of claim and everything. So it is not when you are applying for the default judgment before you be crafting it. That has been settled already. Except that when there's a default judgment, for you to know, when there's a default of appearance, for you to know whether you are to go for a final judgment or interlocutory judgment, you have to go back and look at your writ and look at what was endorsed there, and you interpret it. What I put there, does it meet the test of a liquidated what? Damage? Or it does not meet that? And you learn something in law of contracts. It's applicable mutatis mutandis. You remember the Laudanidin's formulation when it comes to liquidated damage clause and penalty clause. Remember that one? Dunlop and Selfridge.
Yes.
You see, Law is not learned in silos. Law is like a kente for the small. See how it is. It's weaving, interweaving what? Together. So it's not the case that you've learned something there and then it has no relevance. No, law is not like that. We teach you by subject just for purposes of order in teaching and learning. But when it comes to the workings of the law, it's not like that. When cases come before us in court, the cases are not presented as cases in contract or cases in, criminal. Of course, criminal law, that's public law, is different. The story will come just like that, isn't it? We had the judgment we gave yesterday. A land case, but there was a registration of business names and company law point in what? In it. We have a company which claims to have had a grant of a land and that the deed of the assignment was actually made in the supposed trading name of the company. You know, under the Registration of Business Names Act, the company can also register business name, isn't it? So if you look at the deed, the company's name itself was not there, but it's registered what? Business name. Then in the course of time, we had to dig and find out when was the company name, the business name registered. And realized that at the time that the deed was done, the business name was not registered. And if it's not registered, it cannot even be linked to the company, isn't it? So you see how the land matter, and a small company law point can change everything. And the company actually lost the case. So that is how it is. The law is, connected. Now let's look at another type of claim. We have a claim in debt. So if you look at the 10.3, where maybe somebody has retained your goods or somebody is keeping your goods and you have sealed for delivery or yielding up of possession of those goods. So that is an action in what? Indebting. And you have caused a rate to be saved. The person has defaulted in entering appearance. What happens? Can you go and get a judgment in default of appearance? Can you do that? Yes, of course. Order 10.3 says that you can get a judgment in default of appearance where the claim is a debting, that is asking for recovery of goods or yielding up of goods as it were. But the default judgment will not be final judgment. It will be, how will it be? Interlocutory what? Judgment. And if it's interlocutory judgment, what will happen? Sorry? Assessment of what? Damages. So usually when you go for the application for interlocutory judgment, you do two things. In asking the court for the interlocutory judgment, you also ask for a date to be fixed for assessment of what? Damages. So that you go and serve the court notice and also the hearing notice on the party that this day, yes. There's a question. Yes. Give the mic to him. Yes.
What happens?
The liquidated claim and order 10.1.
What happens? First, something cost. As
So how do you compute the interest? Yeah, liquidated. So the interest is capable of ascertainment. So either the contractually is felt as well as part of the claim, or by using the CI 52 award of interest on judgment, like whatever regime it is, it can be ascertained or can be computed. So it will not make it necessarily interlocutory judgment. No. Then with respect to cost, cost follows the event, isn't it? So just as if a final judgment, assuming there has been like a full hearing, and then a final judgment is being given, when we pronounce the judgment, we deal with the issue of what? Of course, under the 74. Unless you want to do what we call the taxation of cost. There are two ways of going about cost. We have just leaving it to the discretion of the court. Or you can be very formal about cost. You go through assessment, what we call taxation, in which case you are going to enter the box and prove all the expenses and everything you think you have incurred by reason of that litigation to enable the court to look at it and make a determination. That regime is there, but it's not popular. Lawyers don't usually do that. Often, they will just agree among themselves. They leave it to the discretion of what? Of the court. Yeah, so that is how it is. But if you don't want that and you want to go the elaborate way, you want to go through taxation, of course, that can be done. Yeah, so we've seen that you have to get interlocutory judgment, and then date will be fixed for assessment of damages. Now, it is possible for you to have multiple defendants. Some have entered appearance, others have not entered what? Appearance. And that is why it's important how you craft your claim or the reliefs on the rates. This jointly and what? Severally. It's important. So if you have crafted it well, because some may enter appearance, others don't. Those who have not entered appearance, you don't have to go through the burden of proving any case what? Against them. You can just get the judgment in default of appearance. Then the case will have to continue in the normal way against those who have entered the appearance as it were. Now, if you have been served with a notice of hearing of assessment of damages as a defendant and you come to court, you can be heard only in respect of the damages. That is to say that you cannot contest the liability. The interlocutory judgment means that the court has settled liability against you, that you are liable. When there's a case before court, in a civil case, you are liable or not what? Liable. Just as in criminal case, you are guilty or not what? Guilty. So for civil case, like especially where you have interlocutory judgment, and interlocutory judgment is entered, what it means is that liability is sorted. The court has found you liable. But then we need to know the details of that liability. And that is where we need to take the evidence, because interlocutory what? A judgment. It was an unliquidated claim. But if it was a liquidated claim, your liability is established. At the same time, we know the details of the liability. Now, what about immovable property? Let's say the claim is about land or interest in land, which is movable property. You have entered and you've served the writ. No appearance has been entered. Can you get a default judgment in respect of movable property? Can you get it? Will it be final or interlocutory judgment? Please look at Order 10 Rule 4. Read it for us. Order 10 Rule 4. Order 10 rule 4.
Rule 4, payable possession of immovable property. B, the defendant is for possession of immovable property only. The defendant fails to have appearance. The plaintiff may, as of the time limit for appearance, apply for judgment for possession of the immovable property and cause as the defendant. Right that the plaintiff may proceed for the action against other defendants, keeping without appearance.
Good. So as you notice from order 10 rule 4, it is permissible for judgment in default of appearance to be entered where we have movable property or where there's even a claim for possession. Sometimes you are seeking to recover possession of movable property. You can get a judgment in default of what? Appearance. But with respect to the possession, we have a big caveat. And particularly so, where you have more than one defendant. Let's say that there's a house, you want to recover possession. There are 3 defendants. You serve all of them. 2 have not entered appearance, 1 has entered appearance. Order 10, rule 4 says that you can get a judgment in default of appearance against the 2, against the 2 that have not entered appearance. But despite the fact that you'll be giving the judgment, you cannot go and take possession. You need to go through the normal trial with the 3rd one who entered appearance. Before, if you are successful, you'll be able to have the fruit of the victory you had against the first 2. So that is how it is. And that is why order 10 rule 4.2 is quite explicit that where there are defendants who have been sued jointly, judgment entered under this rule shall not be enforced against any defendant unless and until judgment for possession of the movable property have been entered against all the defendants. And of course, later on, when we are learning about the execution of the judgment, when it comes to possession, right to possession too, it cannot be issued unless all those who are in actual possession of the property, in respect of which you are seeking to have a right of possession issued, have been served with notice. So if you have 100 people living in a property, each of them should be what? Should be served before the court can consider whether a right of possession should be issued or not. Because when the right of possession is actually decreed, it will involve the use of force to throw out people who are there and give it to the lawful person. And that is why the rules are quite cautious to ensure that there's fairness to everybody. So if people are in possession, let them be aware, whatever they have to tell the court, they will come and file the necessary process and let the court know before final orders will be will be made. And some people are so wicked that when they're actually implementing right of possession, they get all the preparation done. Sometimes by 5 a.m. or 4 a.m. They will come and throw out the, yes. Some do it with so inhumane, you never recover your property. Now we know potential wicked landlords and landladies among us. Yes.
Family bounds in each apartment. Do you consider each family as a unit? Because you said you have to serve each individual.
Yeah, so I'm sure like it's one room. Is that rooms? Isn't it? So we said the people occupying the various rooms or the apartment, as the case may be. The nuances will depend upon the particular scenario you have on hand. Yes. But the principle is that you should notify all those involved in possession. Now we also have what we call the misclaims. When we say misclaims, we can have a case where there's an aspect of a liquidated claim. We have a movable property and so on. So where there has been a default of appearance, how do we go about that? So under 10 rule 5, the 10 rule 5.
Well, the basis for public means to prove one or by an either defendant, and there is no other plea, the defendant fails to file appearance immediately after the time before appearance. Filing judgments against the defendant with respect to cases claim, as it will be entirely to apply for under those rules, if that part the only claim made. See for the action against the other defendants.
Good. So order 10 rule 5 is talking about a situation where in your writ of summons, you remember joinder of causes of action, as well as the joinder of parties. Remember that. Good. So your writ of summons, you are looking for recovery of some debt. The amount is actually known. And you're also looking for general damages for breach of what? Contract. And then you're also looking for maybe declaration of what? Of title, as it were. It's permissible to lump all these causes of action together. It's not against the rules. So where you have done that, and there has been a default of appearance. Now, if you look at the reliefs, they are mixed in the sense that some are liquidated, some are unliquidated, some are immovable property claims. And that is where order 10 rule 5 is saying that in a situation of a misclaims, where there has been a default of appearance, you can still pick and choose which of the claims you can, for example, get final judgment, assuming that were to be like the only endorsement, as we have under the 10 rule 1. And then which of the claims you have to take interlocutory what? Judgments, as it were. So the fact that you have misclaims does not mean that you cannot get a default judgment. You can get. And that is what the rule is telling us. We also have a situation where you have endorsement or relief on the writ, which cannot be treated as any of these four. It cannot be treated as liquidated demand, cannot be treated as unliquidated demand, it cannot be treated as an action for detinue, it cannot be treated as action relating to movable property or possession, as the case may be. And in fact, when it comes to a writ, and that is why a writ is a very is a preferred mode of commencement of action, because of its elasticity and flexibility. It can accommodate all manner of reliefs. It's all a question of how you craft it. How you craft it is what matters. So you can even have a relief crafted, which is outside these known ones. And that is what order 10 rule 6 is talking about. That where you have a type of relief or action, which is not covered by the principles that we are talking about, it is still possible for you to get a judgment in default of what? Appearance. That is all that is telling us. Now, just before we look at how to set aside a judgment in default appearance, I want to remind you of one thing I've said already. The practice aspect. That when you are going for the motion for the default judgment, it will have to be supported by affidavit, isn't it? An affidavit, you need to depose to when the rate and the statement of claim was set. So let's keep that in mind. And that information, where would that information come from? From the search, isn't it? And you have to exhibit that. So when you say that the rate of summons and citizens of claim or served on the so and so on this date, then you can have into bracket vide, VID, vide means C, vide, colon, maybe exhibit, EOD, and there's also the part, assuming I'm the one deposing, exhibit EOD1, search, or letter from the registrar or whatever is there. So the affidavit should speak for what? Should speak for itself. And then you have to talk about the fact that the 8 days have lapsed, or the period limited for appearance have lapsed. And then there's no filing of appearance. And then the search from the registry confirmed that. So when this information are there, then you have set up a good case for the court to grant you a default judgment. So let us keep that in mind. Now, because of time, let's jump straight to order 10 to 8 so that we can discuss other things. Setting aside judgment in default of appearance.
Move 8. Set aside judgment. The court may on some terms, as it thinks fit, set aside all very judgment and enter in response of this order.
Good. So whether it is a final judgment or interlocutory judgment, it can be set aside. The court has the discretion to do what? To set it aside. So let us keep that in mind. Or the court may not set it aside completely. The court may make a variation. So let's suppose that you're supposed to go for interlocutory judgment, and then you set up your application for final judgment. So later on, you go to, for example, before you can implement the judgment, that's what we call the entry of what? Judgment. You cannot enforce any judgment unless you have filed and served the document you call entry of what? Judgment. So the entry of judgment is the official summary telling the party affected by the judgment the terms of what? Of the judgment. Not the whole judgment the court has written, but the orders, the dispositive orders, or the orders of disposition which the court has made. There's a way of putting it. That this matter having been heard by the court presided over so and so and so and so. Then the court, it is hereby adjudged that A, the defendant pays 10,000 Ghana cedis, an interest on so and so and so and so. So that is the entry of what? Judgment. So when you go to serve the entry of judgment, for example, in respect of a judgment in default of appearance, which you obtain as a final, and then the defendant becomes aware. The defendant says that, but if I look at even the rate, that's why the fact that they didn't enter appearance, this should not have entitled you to a final judgment. So you go and file a motion that the court should set it aside. And then the court will look at it and say that, okay, we noticed that there were some other reliefs, and those reliefs were in the nature of unliquidated demand. So that should not have entitled him to a final judgment. So we are going to let the liquidated demand stand. There will be final judgment to remain. But the other ones, which were not good candidates for final judgment, we are going to vary it and let it be interlocutory judgment. You will come and improve it. So it's permissible under the 10 Rule 8, when application is brought for setting aside of a default judgment, for the court to do any of this. So let us keep that in mind. Yes.
Right, so specific to the variation of the judgment, if we are supposed to be the reason of trial.
Yes.
Whereas that if the change process, the history of the defendant at this time now on an application where the court attention or analysis, but assuming the defendant shows
Yes. Sorry. Sorry, my phone should have been off. My security is going. My phone is 99% in silence mode. So phrases. Okay, all right. Yes, let's continue.
So if it is and then also to change the judgment from the final judgment from the legal judgment when it detects that it has given the final judgment, even though it was supposed to give it and the other one.
Well, if you look at Musi and Bejina, which is still a good law, where a court has actually made an order or judgment which is wrong, and then the court becomes aware of it immediately, the court, as a matter of justice, SW2 Justice, can actually do the needful, as it were. Yes. That the Lumba. What does it done? Are you a side check? Are you a side check?
No, within 1 hour, they change the guideline.
Okay, if you're a side check, we'll look into it when we finish. Right. Having followed that case, so now there's one thing which is very now what about where you bring an application under 10 rule 8 to have a default judgment set aside? Since an application, it can go either way. Application can succeed, application can work, can fail, isn't it? And a lot of lawyers think that applications are just a matter of asking. That we just go to court, and they want to go to court, the court is going to grant it. No. You can get a judge who is very strict and who will say that despite the fact that even this application is not contested, you haven't satisfied the requirements of what? Of the law. And you refuse it. So let's assume that you've gone to set aside judgment in default of appearance, first one to order 10 rule 8. And the court said that we will not set it aside. What can you do as a remedy? You are the defendant. You wanted to set aside the judgment entered against you in default of appearance. What can you do? Well, you need to appeal. But appeal that you do will have to be two things. You have to appeal against the judgment itself. And at the same time, the ruling refusing to set aside the judgment. And of course, if it is an interlocutory judgment, you have 21 days, isn't it? But maybe your luck may be that if there is an assessment of damages, in which case it will move beyond interlocutory to final. If there's assessment of damages and then the court proceeds, it's no longer just interlocutory, isn't it? So look at the Ghana Football Association against Apadi Lodge Limited. Ghana Football Association against Apadi Lodge Limited. 2009 Supreme Court of Ghana Law, SCGLR 100. And the Supreme Court made the point that Ghana Food GFA against Apadi, APAADE, Apadi Lodge. So in terms of timelines for appealing. The Supreme Court made the point that time begins to run from the date of the default judgment and not from the date of what? Refusal. So not when you brought the application to set aside, which was refused. That would be the point for calculating time for appealing. No. The time for appealing will be calculable from the date that the judgment in default appearance was what? Was entered. Now I want us to jump right away and introduce pleadings before we go. But we are behind time. Yeah, so just 1 minute. Just get up on your feet and then sit down. Don't go out. There's a gentleman who sits here. Where's Petakis? Where is he? No, no, there's another one. Yeah, why? He uses a tablet or something, isn't it? No, not him, I know him. It's another one. There he sits.
The one who's in there, the one.
Yes.
He's not in today.
He's not in today. Oh, right. Okay. You ask, that's a good friend. All right, okay. I'm not surprised how she was interested in the Lumber's case. Okay. Yes, please. You can sit down so that I can continue. Yeah, so we are going to have about 2 or 3 lectures on pleadings. So we'll introduce it tonight. So pleadings. So whether you'll be a very good practitioner or not, to some extent depends upon how you develop your skills to write pleadings. So what are pleadings? Pleadings are formal written statements. Formal written statements of material facts. Material facts upon which parties rely in support of their claim or defense. So whether you are plaintiff or you are defendant, there are certain important facts grounding the claim you are making or the defense that you are putting up. And when you state them formally, we call that pleadings. And pleadings are the means by which the parties bring their disputes before the court for adjudication. The court was not there when whatever you are talking about happened. But it is the pleadings which will let the court understand what the controversy is about. And that is important because when it comes to trial, what is the point about trial? Trial is for you to adduce evidence in support of your case against your opponent. But when the court is in session, Should the court allow you to bring all manner of things during the hearing of the case? No. So pleadings define the parameters, the boundaries of the dispute. It narrows the dispute. And it serves as a compass which governs the adduction of evidence in a trial. And that is why when a trial is going on, evidence will be introduced. A lawyer will jump on his feet. Objection, my lord. State the ground of objection. The witness is testifying to a matter which is not consistent with the pleadings. Then the court will have to actually, the lawyer for the witness whose testimony is being objected will have to get up and reply. And the reply, you have to link whatever the witness is trying to say to your pleading. If you're not able to do that, and the court will look at it, the court will sustain the word, the objection. And the well-known case, Dam against J.K. Ago and others. DAM, that the Dam against J.K. Ago and others. 1962 2JLL 200. The Supreme Court reminds us that parties are bound by the cases they put forward in their pleadings. And the court is not entitled to decide the case outside those pleadings. Or the court cannot ex proprio motu set up a case, or mero motu, or so motu, the same thing, set up a case against, set up a case for a party. No. So if the court, for example, gives a judgment or decide the case, which is outside the pleadings, the court, as it were, will be helping build a case for one party against the other. Because when two parties go to court, and that is why we call pleadings the paper war, before the case is actually ripe for trial, we have actually traded a lot of things between us, making formal statements of our respective claims and formal statement of whatever defenses the other one has got. I will say something as a plaintiff against the defendant. You may look at it and consider, yes, I admit this thing you are saying. However, I have that. And then now, as a plaintiff, I may also come back and reply you until we're able to narrow the controversy or the contention before us. So pleadings are very important. So when we say having understood pleadings, what form part of pleadings and what are not part of pleadings in terms of documents? Writ of summons is not a pleading. Let's get it right. Writ of summons is not what? It's not a pleading. Writ of summons is not a pleading. It's just an originating what? A process. It commences an action, but it doesn't set out the factual basis of the claim. Entry of appearance is also not a pleading. When you file the entry of appearance, you've not pleaded. It is a mere notification of intention to defend what? The action. Or you have not given any factual averments regarding what your defense is. So entry of appearance is not a pleading. Now let's jump to order 82, the interpretation section of CI 47, or the 82 rule 3. Or the 82 rule 3. And you notice that pleading has been defined. And according to order 82 rule 3, pleading means the formal allegations by the parties to a lawsuit of their respective claims and defenses with the intended purpose of providing notice of what is to be expected at the trial. Very simple but incisive definition. So from order 82 rule 3, in terms of understanding pleading, we know that it is a formal allegation or formal statement of what? Allegation. Meaning that if you just write letters or just WhatsApp messages, it's not a pleading. There's something of a formality about the pleading. And that is why if you look at order 11, in the course of our discussion, we come across certain formal requirements which a pleading must have. And that is why we're saying there's a formal allegations of a claim or defense, as it were. And what is the purpose? Order 82 rule 3, in defining pleading, will remind us that the intended purpose of the pleading is to what? Provide notice of what is to be expected at the trial. So to avoid the element of surprise, we do not want what we call the ambush trial. In fact, ambush trial or ambush litigation is long dead and gone. So pleadings are supposed to give a fair notice of what claims or what defenses a party is making against what? Against the other. So let us keep that in mind. So therefore, under our law, under CI 47, which governs litigation in high court and circuit courts, when you talk about pleadings, we are talking about statement of claim, statement of defense, and reply. So statement of claim, statement of defense, and reply. Of course, we are aware that under the current civil procedure regime, unlike the old one, LN 140A, where a writ will be issued and served, and then after this, you have the statement of claim. So the two did not go at the same time. Now, under the current regime, a writ must be accompanied by what? By statement of what? Claim. But that notwithstanding, a writ is not a pleading. And in fact, a person can get a writ issued without statement of claim. It will not automatically be void, except where somebody takes it up. And if someone takes it up, the court can order the plaintiff to file the statement of what? Statement of claim, as the case may be. So a writ is not a pleading. So a plaintiff's pleading commences with the statement of claim. And the defendant's pleading commences with the statement of what? Defense. So look at the case of Gihog Refrigeration and Household Products Limited. Gihog Refrigeration and Household Products Limited against Anna Asi number 2. 2007-2008. Hannah Asi ASSI number 2, 2007-2008. SCJLR 16. And over there, that case, I'd like you to read it. And know that we're having a challenge where during a trial, evidence is allowed to come in, that is, to be received into the record without objection, which will have been taken. And at the end of the case, the reliefs, maybe the court may make certain orders. But then if you look at the pleadings, which were actually exchanged before the trial, it may not perfectly capture an important part of the evidence which has come, which is going to be the basis for certain orders. And then another is telling us that the court should not decide a case outside what? The pleadings. Otherwise, the court will be ex proprio motio, actually setting up a case for one party against what? The other. But Order 16, you will notice later on, allow amendment of what? Of pleadings. But the party did not take the steps. So, and Nancy, I'd like you to read it, where the Supreme Court were actually divided, even on the review, as to whether the court, in trying to do justice, especially so when the evidence have come, whether the court should just allow the technicalities of pleadings, that if they haven't pleaded it, then the court cannot give judgment or orders outside the pleading to stand in the way of justice, or the court can just on its own invoke powers under Order 16 and make requisite amendments so as to justify certain orders the court would like to make. So in terms of the statutory framework which governs pleadings, we have to read Order 11 before we have our next class. Read the whole of Order 11.
That's class.
Yes. I'm very much aware. So Order 11 regulates what must be pleaded, how it must be pleaded, the consequences of defective pleading, and the powers of the court to control pleadings. Of course, Order 11 is not a straight-jacketed, like a technical code, as it were, but it's designed to ensure that there will be fairness on both parties and also efficiency. So when it comes to the essence of pleadings, I have 5 minutes so I can do a bit more teaching before I go. When it comes to the essence of pleadings, like the heart of pleadings, just as part of the introduction, we come and look at the nuances later on. The essence of pleadings is the principle of fair notice. And we saw Order 82-3 that pleadings is intended to do what? Intended to serve as what?
Expected during the trial.
Yes, what is expected during what? The trial. So the first principle is what? Fair notice. So each party is entitled to know in advance of trial the precise case he must meet and use that to actually gather your evidence, isn't it? And also to position yourself to try and tear apart your opponent's case. Because you know that whatever evidence is going to bring will be along lines the framework of the evidence. Of the pleadings. So use that to also hold yourself in readiness. How to try and demolish or how to tear your opponent's case. And we've cited Dam and what? Ado, that it is wrong for cases to be determined on matters not pleaded. And that will amount to procedural injustice. Another point just before we go is that pleadings serve as a limit on judicial power. In what way? Pleadings limits the power of the judge, who has a constitutional function, isn't it? And Dam and Ado tells us that because you have adversarial litigation, a judge does not have the power to substitute his own case for that of the parties. If the parties have poorly presented their case, and if you were in their shoes or one of their shoes, you have set up like a different case, that should not feature in your judgment. Otherwise, you'll be descending into the arena of what? Of conflict, as it were. Remember the case of Ghana Muslim Representative Council against Salif? I hope you've read it by now. Who has not read it? Okay. So Ghana Muslim Representative Council against Salifu and others, 1975 2JLR 246. I haven't downloaded it for you, just about a few pages. So just before you leave, we can say that pleadings define what the court may decide. Pleadings restrict what evidence may be led. And finally, pleadings protect party autonomy, the litigant's freedom. Yes. What the court define what the court may decide, because the court cannot go outside the pleadings and do its own thing, isn't it? And then it's also restrict what evidence may be led. You've done law of evidence, isn't it? You've done the rules on the relevancy, isn't it? Good. So what is the principle on the relevancy? Yes. Yes, like what is it like the, what is the essence? What is relevant evidence? Relevant evidence is what? Admissible. And so what is a relevant evidence? You still haven't answered my question.
That is directly
linked
to the issue.
Good. And how do you know the fact in issue? Pleadings. You see the connection. You see the connection. So civil procedure and evidence, they go together. Criminal procedure and evidence, they go together. No wonder the law reform they are doing, they want to merge this. You know, like from next year going, they are going to change the way professional legal education is organized. And as I told you, like in learning pleadings, aspects of evidence are very important. And you see it as we read order 11, isn't it? We read order even amendments, order 16. So it's not the case that evidence is a distinct area of law on its own. Civil procedures are distinct on this one. No. They all serve each other. We just break them for purposes of academic organization. But in reality, there's no case which will come before the court as evidence case, or case which will come before the court as civil procedure case. There's nothing like that, isn't it? So before you go, I want to reiterate for you that no matter how strong the evidence, it cannot cure a case that is not pleaded. That's the last sentence I'll leave with you before we continue tomorrow. That no matter how strong the evidence, it cannot cure a case that is not pleaded. What does that imply? Now, if you're a lawyer on the other side, you must be alert Don't be casual, be prepared. When you are going to do litigation, be prepared. Being prepared means that immerse yourself in the pleadings. Read the pleadings many times. A statement of claim, statement of defense, reply, counterclaim, and so on. And know the issues that have been set down for trial. So that when the trial is going on, you know what to tolerate and what to object. But if you are very casual about it, and a lot of, from my observation from the bench, a good number of lawyers, they don't do good preparation before they come to trial. If I say good preparation, they don't bother to, spend time to go back on the pleadings. Because usually the pleadings might have been filed sometimes a year, 2 years, I mean 3 years before the case will be right for what? For trial, isn't it? Or sometimes you may not even be the lawyer who prepared the pleadings. Maybe you're in the chambers, somebody else prepared the pleadings, but that case is assigned to you are conducting the trial. Or the case is inherited from another one, firm. So you must immerse yourself in the pleadings. And once you know that, it will help you to conduct a good cross-examination and also police the evidence which is coming in and which should be prevented. All right, so we continue tomorrow. You have another class. Oh, right. Okay, that's good. So you were for the car. Is that I'm not like this one?
Yes, like this one, but it's small.
Small. Good. So please, can you go and bring it? I'm sure that I want to take something in it quickly. I'm waiting for you.